technically in the law, the people who are responsible to obtain a license are the person managing, the person having control. These have no relationship to plain English definitions, so person managing doesn't mean a managing agent. The summary position is, if you collect the rent, either for yourself or on behalf of anybody else, or you are in receipt of the rent, then you are liable for the property's HMO status. Now that can mean several people. That can mean a managing agent and a landlord, and possibly their superior landlord as well. So there can be a chain of people who are all liable. And any of those people can be prosecuted, or in fact, in many cases, all of them can be prosecuted for a failure to license. So if you're letting a property out and think, oh, I've let it out, it's not my problem, it's being sublet, it is still your problem. You need to keep an eye on it. If you've got a managing agent and they've said they're going to sort out the HMO license, it's incumbent upon you to check. If you are a managing agent and you've told your landlord to get the license, it's important that you go and make sure the landlord's actually done it, because all of you are equally liable because you're handling the rent. There have been some cases recently which have gone even further that have suggested that even if you just handle the deposit and not the rent, you're still potentially liable because of the way the legislation is framed. Those are probably going to be appealed, and it's a more complex issue. But the general position is, if you're involved in the management or operation of property at all and you've had money associated with it, then you are at severe risk if that property is not properly licensed and being properly managed. So you need to keep an eye on it. In terms of license applications, the offence is committed if at any point the property is occupied as an HMO and a license hasn't been applied for. So I see lots of people who say, oh, well, let's get the tenants in the property first and then we'll apply for the license. That's a pretty risky strategy. Now, in practice, if you do it within a couple of days, most local authorities aren't going to mind that much. But there'll always be a few who will. But of course, if your couple of days turns into a couple of weeks and then you're a bit busy and it's a couple of months, and then actually you discover you don't have all the things that are necessary to get the license application, so it's 4 months, the local authority is going to mind, and you're going to get prosecuted. So it's really important to bear in mind that really you should have a license application in before occupation begins. And once the application is properly made, that's okay. So having an application properly made is the same as having a license. So it's important to get the application in early. But it's only true to say that having an application is as good as having a license if the application is properly made. That means properly completed, with notifications sent to your mortgage lender and all the people you're required to send notifications to, and having paid the proper fee. So I often see people who don't complete the application or send half an application and think they're protected. They're not. You must make a valid application, and you really ought to do so before people move in. I certainly see when people are doing developments, they have a timeline built in, and none of that timeline includes the HMO license application. It should be in your development timescale and timeline, preferably before your tenants move in.